Yes, Ms. Finesse.
Thank you, Your Honour. There are two representatives of the Coalition of Aboriginal Services who are here to speak to their submission. Thank you. Ms Singh, would you introduce yourself and your organisation?
I don't think you're being picked.
Maybe.
Try that.
Is that better? Yep. Sorry, my name's Meena Singh. I'm the Acting CEO of the Victorian Aboriginal Legal Service. We're a member of the Coalition of Aboriginal Organisations, which represents some 10, 12 community-based Aboriginal organisations in Victoria who assist people to make contact with the Royal Commission and also ongoing support as well.
Thank you. And Mr G?
My name is Graham G. Excuse me. I'm a counsellor and psychologist at the Victorian Aboriginal Health Service, which is one of the partners of the Coalition Services. I've been practising counselling and psychologist at the Victorian Aboriginal Health Service since 2008.
Thank you. Can I invite you to speak to your submission?
Thank you. Before we commence, I'd just like to pay my respects to the traditional owners of the land upon which we meet, and also pay my respects to their elders past and present. I also pay my respects to elders here with us today. Rather than just reading or pulling out specific aspects of our submission, partly which is what Graham will be doing with his work, my task is to raise three particular issues for consideration, and I draw from our coalition submission but also some previous work that's been done by the Victorian Aboriginal Legal Service in response to issues papers 6 and 7. So obviously the scope of the Royal Commission is focusing specifically on sexual abuse. What we're asking for firstly is in consideration is recognition of cultural abuse as a distinct head of redress within any civil redress scheme's ambit, something that's considered in addition to and equal to sexual, physical and emotional abuse. It's the Coalition's view that if we're going to be providing any real sense of healing or justice for Aboriginal children who were removed and then abused within institutions, we need to look at the very reason behind their removal, which is the fact that they were Aboriginal. So in that sense, I guess that raises issues around standard of proof and how we actually address that. And there's been some discussion this morning about plausibility. We will be looking at a model that says that the very fact of institutionalisation of Aboriginal children is grounds for some sort of redress and attention. Secondly, as our community consultations show, there's been a willingness in the community to think holistically and creatively about what a redress scheme looks like. We also ask that you dare to imagine a civil redress scheme that doesn't just cater to institutions that committed the abuse, but wholly supports the individual to seek some measure of justice and healing. And by this we mean a process that is responsive, survivor-focused and culturally appropriate specifically for Aboriginal people. And that's to say that legal processes and cultural safety do not need to be mutually exclusive. They can actually work in tandem together to support the experiences of Aboriginal people going through a civil redress scheme. We see civil litigation, all the features of civil litigation, the adversarial nature, the heavy reliance on documentary evidence, the antagonising of people's evidence, as those are features that really don't belong in a civil redress scheme. We need a civil redress scheme that needs to be efficient, flexible and accessible by all. And considering the cost that's involved in accessing traditional civil litigation, it's really a misnomer to think that that's a viable option in addition to a civil redress scheme. When we think about the long-term ongoing impact of abuse of children in institutions, we know that there's high rates of mental health issues, high suicide rates, low employment, there's a whole range of barriers that mean that people can't access traditional civil litigation schemes. And so we ask that there's some flexibility around things such as how evidence is given as part of a civil redress scheme, the opportunity and greater importance provided in regards to oral evidence in particular, an onus on institutions or on government on actually finding and accessing written documentary evidence. We know for a fact that so many Aboriginal babies weren't registered for all sorts of reasons. Their births weren't registered. And so there's whole gaps in identity of Aboriginal people that really need to be addressed. And finally, before I hand over to Graham to speak more intricately about what came out of our community consultations and some of the therapeutic approaches, we'd like to think about how a redress scheme reaches out to the very people who need to access it. We know, working in the legal assistance sector, in community health, working with families and children, that those in the greatest need, those in the most state of crisis, are the last people to ask for help. We also know that Aboriginal people feel much safer and more comfortable accessing Aboriginal community organisations. That's where they feel at home. That can be for a whole host of reasons, from out-and-out racism through to simply not feeling that their experiences as an Aboriginal person are heard and understood. And so I guess what we ask for is a continued working with Aboriginal community organisations on the ground, accessing our knowledge, and also using us as a way into communities and reaching those very people who need to access civil redress, and also vice versa as well. But I'd like to hand over to Graham now.
Thanks, Mina. I too would like to acknowledge the traditional custodians of the land and the elders past and present. Following Mina, I just want to take the opportunity to reaffirm some of the key points from the Coalition's recent community forum and our submission to the Royal Commission. At our recent Redress forum, it was clear to survivors and other community members and the Coalition, and no doubt this Royal Commission's aware, we're all painfully aware that the Aboriginal community has already seen a number of inquiries, and Royal Commissions make significant recommendations for redress, for which there's been little response from the Australian Government. The Coalition believes that the same principles and procedures as outlined in the Bringing Them Home report, particularly Chapter 14, can be used to inform this current work on redress. And we acknowledge that the Royal Commission has a difficult task of making recommendations that are aimed towards ensuring that survivors receive just redress for the abuses they've suffered, while also needing to make recommendations that are actually viable for the government to reasonably act upon. And it's probably fair to say that the community, we don't want the heartbreak of not seeing some of the redress recommendations going through this time. Otherwise, it's going to be another inquiry that's failed us in the eyes of Aboriginal people. At our forum, some survivors expressed that they didn't wish to engage with the institution from which the abuse occurred, and others said that they would consider re-engagement for the purposes of closure, provided that it was safe and meaningful and that the institutions were able to accept responsibility for the wrongs committed against the survivor. We do agree with a recent submission that we've read from the Aboriginal Legal Service from Western Australia that emphasised the need for institutional representatives to receive appropriate trauma and culturally informed training prior to engagement with survivors as a matter of safety. One of the biggest discussion points at our recent forum, was around this topic of counselling and psychological care. As Mina has stated, for many, though not all, Victorian Aboriginal survivors, their experiences of child sexual abuse co-occurred along the denial, and in many cases severance, of their connections to their cultural heritage. And many survivors in Victoria report experiencing a profound sense of cultural alienation that impacts their self and their identity and their lives as much as the experiences of child sexual abuse. And it's for these reasons that many survivors report they have experienced the benefits of individual counselling, but for many, the psychological model that's here at the moment falls far short of their healing needs. And this was a great concern among the survivors at our forum. They expressed the need for cultural healing programs that not only address the interpersonal effects of child sexual abuse, but help them to reconnect to their culture, to their local communities where they had often felt alienated, and to restore their fundamental identity as Aboriginal people. And given that, it's particularly disappointing to hear of the Commonwealth Government's current view on the scope of counselling and psychological care in the redress scheme. And I suppose that we would urge the Royal Commission to further explore this issue with the Commonwealth Government, given that they were responsible for the removal policies of Aboriginal children, at least up to the time of the referendum. We would like to bring the attention to the Royal Commission that there is a small but very significant evidence base for the role of culture in healing sexual abuse within Indigenous contexts. We briefly note here the decades work of the Canadian Aboriginal Healing Foundation that was established in 1998 in response to the legacy of physical and sexual abuse suffered by the First Nations peoples of Canada in the Indian residential school system. Because their findings, and we have our own healing foundation, but it's still gathering evidence and evaluating their programs, but they found that the best healing practices were a combination of learning about history, of cultural practices and psychotherapeutic work that included Western modalities to work with sexual abuse and so forth. And we believe strongly from our forum that this was the way to go, that we need all three of these healing modalities in order to heal our mob. Very briefly, of the financial options that were presented, in our forum, the preference was for the highest figure of $80,000 average payment with a maximum of $200,000. Participants also felt very strongly that being a part of the stolen generations and suffering from cultural abuse must be taken into account when calculating payments under the distinctive institutional factors. And finally, consistent with other views that have been shared here today, there was a clear view that a national scheme was preferable to either the state or institutions establishing the scheme. And whatever process is decided upon, we would hope to see Indigenous input with regards to that process for Aboriginal survivors.
Thank you, Mr. Chair.
Thank you. Can I ask both of you, but either can answer or both of you can answer. You raise a number of significant and complex issues, and I know you appreciate that and what you've said. One of them is the proposition that institutionalisation at all, absent sexual abuse, should be recognised in the redress scheme. I can understand, and all the commissioners can understand what lies behind that. Have you thought about how that is reconciled, if at all, with the fact that there are many people who were children and placed into care away from their families, many of whom were, for example, child migrants, and many others in the community who were not in the care of the Commonwealth, or for which the Commonwealth had responsibility as Aboriginal children? How do we reconcile all of their issues, again, if they haven't had sexual abuse, with what you're asking for in a redress scheme that we might recommend?
Yeah, okay. We're obviously presenting an Aboriginal specific experience, and so we focus very much on the fact that children were removed because of the fact of being Aboriginal, and there's a whole, that's just one reason for children being placed in institutions. So we're specifically looking at the responsibility in children removed for the very reason of being Aboriginal, and what's part of that is that they weren't getting the proper upbringing, or however you want to put it, within their own families. So that we see that as creating an additional onus, because it's saying that government is saying we know better and we know how these children should be raised, and we put them in environments where they went through abuse. The very act of removal of children meant a breakdown in families, meant a breakdown in traditional languages, meant the inability to observe cultural practices, ancient traditions were severed for decades, until people were able to reconnect with family, and sometimes too late, when after their parents had passed away. So we understand how difficult it is, that there's a whole range of issues and reasons why children were placed in institutions, but specifically for us, that's all we can really comment on in regards of that.
Thank you. And secondly, and I'm sure all the commissioners and everyone in this room would respond to the proposition that the scheme should be accessible and available and lack formality, if possible, in its processes so that people, as far as one can make it, will feel comfortable in coming to a redress scheme. But that means, however, that you can't avoid the criteria that might provide for eligibility in such a scheme. What are your thoughts on the standard of proof, what someone would have to demonstrate before they're eligible under that scheme? Plausibility, reasonable, balance of probabilities. Where do you think the Commission should come down on that issue?
We're in favour of plausibility. In our redress, in one of our responses to issue papers, we raised the example of the Canadian Redress Scheme's Common Experience Fund, which looked at, and I believe it was also raised earlier this morning, about institutions where it was known that abuse was widespread, and proof of being placed in that institution under that Canadian scheme would allow a compensation amount of, I guess, a baseline amount, and then for every additional year that someone was in that institution, there was an additional monetary amount awarded. So again, we go back to the fact of institution, and that if a child was placed in a particular place, the very fact of institution is causing some sort of distress, and then looking further at what actually were the experiences of the person inside.
I'm going to test in a particular way. If you have a matrix that provides for injury as part of the arrangement, what do you see as being necessary to show in order to have the redress scheme accept that you've been injured, not just abused, but injured by the abuse?
As in, what sort of evidence would an individual person provide?
Yeah.
So in terms of giving oral evidence, or whether there was evidence of a report of abuse being made?
What are your thoughts about what you'd need to show and how you would do it?
There needs to be a lot of support for people to give their oral evidence, and looking if a civil redress scheme was to continue after the Royal Commission, possibly looking at people who have told their story to the Royal Commission as using that as evidence in subsequent redress schemes would be one way to support people to show evidence of what had happened to them. Part of the issues is obviously re-traumatising of individuals as they're telling their stories. So, and we're also talking about children in care, so records or evidence of complaints of abuse.
But do you see it as being necessary for there to be a report from a professional that demonstrates the damage to the individual?
So you're talking about the actual impact rather than the incident of the abuse?
Yeah.
Great.
Yeah, that's... Yeah, I would agree with that, and I would just probably add that the views of the participants at the forum were that severity and impact need to be given equal weighting, and that cultural abuse be considered as a separate factor. And there was quite some robust discussion with survivors themselves around that.
Yeah. Well, these are complex issues.
Yes.
Difficult issues.
Appreciate that, yeah.
Yes. Ms. Finnis, do you have any questions?
I do, Your Honour. You referred, Mr G, to cultural healing programs. Are those programs in existence in Victoria?
There are some, but the difficulty is that, of course, they're not being funded by Medicare locals or the Medicare system. We're always looking for resources to be able to fund those, and that's our problem. There are some excellent healing programs like the Maramali program that Arlie Lorraine Peters runs, and the Red Dust Healing Program. We have family violence camps and a whole range of cultural activities around family violence that are fantastic. The community loves them and finds them very healing. But it's a matter of resources, and they do cost. And the Aboriginal community-controlled agencies don't have the funds to fund those, and that's why one of our biggest concerns is that the current system is never going to be able to provide those resources, and it's so fundamental to healing survivors' identity. I mean, the experiences of sexual abuse and being taken from culture, they just don't sit separately. They coalesce together in a potent mix, and so we do need those healing programs, but we are very short on resources to give those programs to survivors.
Thank you. Just one other matter, if I can, Your Honour. You refer in your submission that a person who has been through a redress scheme and received a monetary payment should still be able to access victims of crime schemes and civil litigation. That's right?
Which page are you referring to? My apologies.
It's in page 8. Above the heading distinctive institutional factors.
Yes.
Is it your position that the amount, if any, that is received subsequently through a victims of crime scheme, the amount received is deducted? That is, the amount received under the redress scheme is deducted from any amount available under a victims of crime scheme?
Well, the current Victim of Crime Assistance Tribunal in Victoria is very much tied. There's all sorts of requirements to be able to go through that tribunal, including timing requirements of making a report to police within a certain amount of time. So in its current structure, it really doesn't support historical cases of child sex abuse or institutionalisation. So it would be much more, if we were talking about a civil redress scheme that dealt with more recent or current ongoing issues of abuse. The two schemes are set up for very different purposes. One is recognising that it is, victims of crime is recognising that it's a crime that's been committed against someone, and the state is recognising the harm that's come out of that, and that people can access Victims of Crime Assistance Tribunal and still go on to civil litigation as well. And then that's a decision for the individual. We see a civil redress scheme in response to the Royal Commission's work as being recognition of something very different, that there's a very particular type of relationship between a child and people who are supposed to be caring for them, and that there's a breach of trust of that fiduciary arrangement. So I don't believe I have to get more feedback from the coalition as well, but I would not like to see that one is compromising the other.
Thank you.
Commissioner Fitzgerald, I was just wondering one question. You've mentioned both terms, culturally appropriate and culturally safe. It would be easy for the Commission to put in a document that the process had to be culturally appropriate and culturally safe. But I was wondering whether you have a specific point or points that the Commission should be attentive to in relation to a culturally safe approach.
Well, certainly what I'd like to say is that culturally appropriate and safe means a lot of things, and on a more fundamental level, cultural safety is about having non-Aboriginal counsellors and psychologists, and indeed Aboriginal psychologists and counsellors, understand to be culturally competent, to receive training in cultural competence, to provide a culturally safe environment that's free of discrimination, and so forth. So there's that aspect of being culturally appropriate. The other side of it, though, is that we don't believe that how do I say this? We have a very, very our elders and those people in our community who are giving healing to those who have suffered from abuse and removal, such as Arnie Lorraine Peters and others. They hold a particular form of cultural expertise and knowledge that we cannot get from Aboriginal psychologists like myself or other non-Aboriginal psychologists. They are particular blessings and transmission of cultural knowledge to people that is culturally appropriate, and we can't get that in individual counselling. So that's another area of what I would say is culturally important or culturally appropriate, is that the right people do those healing programs.
Thank you.
Thank you.
Yes, thank you both for your contributions and for the work that you've done to help the Commission. We're very grateful. Thank you indeed.
Thank you.